Business Law, Team 3. Today I'm beginning our presentation with the basic American legal principles. Before starting a business, it is important to understand the aspects of the laws behind this topic, which can help businesses to become successful in providing exceptional customer service and by avoiding legal problems such as fines, penalties, and lawsuits. It is always smart to speak with an attorney who can help with drafting of certain contracts and writing business policies and procedures. As a business begins to work with other organizations or contractors, it is best to have a contract in place to protect their interests in case there is a lawsuit. To ensure all employees understand the policies and procedures of a business, businesses should provide employees with their job description, handbooks, and completed new hire paperwork for protection. Having knowledge of these laws not only protect the business from lawsuits, but it helps the business to understand their role in protecting their customers and employees and being careful not to violate their rights. Slide 2. Other important laws can help businesses be more successful are knowing how to avoid court costs and how to handle disputes and settlement alternatives. Businesses involved in disputes can use a trading strategies method for resolution depending on the relationship between the business and their supplier and how the transactions are made. Businesses can use the negotiations method to help maintain their business relationships for contractual reasons. Sometimes business disputes arise from emotional differences causing people to become angry with one another, but through the group negotiations method, a business can protect their business reputation by beginning to communicate with sincerity with the disputing business party on their desires to reduce conflict by inviting reciprocation to help lessen tensions. Private mediation protects the business reputation so they are not subject to public scrutiny and to prevent loss of business. And although arbitration is cheaper than court, the arbitrator's decision is final and binding, even if the business utilizing this method doesn't agree.
Hi, my name is doing chapter business ethics to build. Business ethics viewed as an outline for building a successful association and corporate company. On the off chance that an association is based on socially responsible qualities, it will be more grounded than an association that is based on benefit alone. Something beyond a positive priority, the center of morals of a business direct how every choice, procedure, and strategy will happen. This ardent administration applies regardless of whether the business faces tough situations or troublesome circumstances. Some will even contend that organizations require full straightforwardness in this day and age. The possibility of business morals may appear to be abstract, yet it boils down to the worthy degrees of conduct for every person who makes up the association. This conduct must be at the beginning with mindful activities exhibited by initiative. Thusly, many corporate businessmen make a lot of decisions that are to be trailed by others in organizations. These guidelines can be found on the profound qualities that the organization has concerning the nature of items, administrations, the responsibility of clients, or how the association gives something back to the network. The more an organization lives by its arrangement of morals, the more it is probable to be successful. Business in the United States. Government and state constitutions are significant wellspring of business law. The Commerce Clause is the main source of authority for federal regulations. The United States Constitution is the preeminent law of the United States. Notwithstanding the individual constitutions set up in each express, the U.S. Constitution sets out the key standards and standards by the nation and individuals are administered. Protected laws is the term used to portray the forces and cutoff points of the administration and state governments as it is set up in the Constitution. Political framework that isolates the power to the administrator gives the state and central governments is known as federalism, and this is also built up in the Constitution. There are 10 amendments that express that any zone over which the national government is allowed authority through the Constitution is safe for the state. This announcement implies that any government enactment affecting business and trade must be set up by communicated powers. The freedom of speech in the provision of the First Amendment have application to corporations. This courts distinguish between different types of speech and has implications for the power and federal government to take regulate in areas. Political speech, unprotected speech, and commercial speech, which is a type of speech that conveys the information pertaining the sale of goods and services. The other is is the Fourth Amendment. The Fourth Amendment guarantees that citizens are free from the unreasonable searches and seizures and require government officials to obtain search warrants to conduct searches. And the Fifth Amendment for commercial enterprises and business people, as it is the due process clause of the Fifth Amendment that offers the most extensive protection.
Chapter 5 is the criminal liability. Criminal laws are offenses against the public, society, or state. Civil laws are actions against one's individual's rights. Examples would be child support, property, and contracts. Businesses could use criminal laws to file claims against employees for crimes such as fraud. Civil laws protect individuals who need to file lawsuits against another individual for lack of child support payments or breach of contracts. White-collar crimes and business crimes are commonalities in the corporate workplace. Employers could use criminal laws to file claims against employees who have committed crimes in the workplace, such as fraud, embezzlement, and racketeering. Chapter 6, the tort system. Torts are intentional wrongdoings against others, which results in a form of damage. Companies need to be aware of the tort system to accept liability when applicable and avoid professional negligence. Tort law is important because the issue at hand is based off of fault. Intentional torts and negligence can easily affect the business outcomes in a customer service setting with the general public or hospitality industries. For example, the purpose of wet floor signs is to make customers aware that the floor is wet, so they are releasing the liability if a customer falls in that area because they were made aware beforehand. This allows companies to properly train staff and be made aware of liabilities a company stands for.
I'm shaking more than you are, probably. Okay. Chapter 7. Chapter 7 would be contract law. Contract laws are important to businesses because it outlines the general rules and laws for building a contract and the expectations of the businesses or any entity providing the contract and the party receiving the contract. It lays all the requirements needed for the specific businesses, and with the breach and remedies of the contracts, it provides protection, solutions, and involves consequences for both the parties if there's a lack of performance or if the expectations aren't met from either side of the party. It also provides information on the capacity and legality of the parties coming into an agreement in a contract and specifies who are eligible to enter into a contract and what is the scope of legality within the contract. And Chapter 8. Chapter 8 is on sales contracts. Sales contracts emerge when there is an agreement of sale and purchase between a vendor, the party who agrees to sell particular goods and services, and the vendee, the party who agrees to buy the said goods and services. Sales contracts describes the type of product and services being sold and its features. The sales contract should specify the type of product, the quantity and quality, and the price agreed upon the sale of the goods and services. It sets an expectation of accountability from both sides in the case of disagreement. It also describes the warranties provided by the businesses under good faith and the types of warranties provided by the businesses and what is received. It expresses handing over the title of ownership of a particular product for legal issues and the warranties of the title that provides more protection.
So Chapter 9, Employment and Labor Laws. For business to be successful, it's important to take care of the employees that keep the day-to-day tasks operational. OSHA, or Occupational Safety and Health Act, provides employers with regulations, guidelines, and training to ensure that the employees understand the potential risks surrounding their job duties and how to act upon emergency if one were to arise. This chapter also provides information on the process of workers' comp in case an injury was unavoidable, so the employee is taken care of and an injury inhibits them from performing their job. Important act is the Fair Labor Standards Act that was enacted in 1938 that set up several important rules such as standardizing the 8-hour workday. It also banned the employment of children under the age of 16 and set a minimum wage an employer can give. This chapter also provides information for situations where an employee might have given birth, adopted a child, taken in a foster child, discovered serious illness of a family member, or any serious conditions that stop an employee from being able to do his job. There is also information concerning job termination, hiring of immigrants, and anti-discrimination laws relating to ethnicity, gender, age, and disability. The chapter provides a section containing information about unions that will affect a business if one was formed, Information is part of the different forms of the union can be created and the various forms that they take shape of, also various negotiation tactics. This chapter provides a general guide for business to be successful as it encompasses the general laws surrounding the treatment of new and current employees. A business cannot run afoul of its employees and has shown that taking care of their employees will increase their performance, leading to a successful business. In chapter 10, we talk about government regulations. Industrialization is a movement of the people from rural work to cities and thus has created a need for agencies to regulate and protect the public. Administrative law are guidelines established for administrative agencies. These agencies are established by statutes and can be governed by either rules, regulations, and orders, court decisions, or judicial orders. A type of statute is organic statutes that are passed by Congress that outlines clear responsibilities and structure on the purpose of the agency. These agencies' purpose can affect the daily functions of business and must be considered by businessmen to be successful. In 1946, the Administrative Procedure Act gave power to the agencies to create and enforce new rules for the agency's directive, but must follow certain procedures to be enforceable. The Food and Drug Administration, the Federal Trade Commission, and the Federal Bureau of Investigations are some of the regulatory agencies created to protect the general public and to regulate commerce. In 2009, the President Obama signed the Family Smoking Prevention and Tobacco Control Act into law that gave the FDA authority to regulate the and manufacture, distribution, and marketing of tobacco products to protect public health. Later that year, with this newfound authority, the FDA banned cigarettes with flavors that characterize such things as fruit or candy. This was to prevent increase in teen smokers and prevent potential addiction to nicotine in the new generation. It is important to always keep up-to-date information of new regulations, as it will most likely affect their process, marketing, or even the raw material they use in manufacturing their products.
Chapter 11, Antitrust Law. Antitrust laws regulate economic competitors in efforts to create fair trade and cease monopolizing. Exemptions are labor, foreign trade, agricultural and fisheries, and cooperative research and production. These acts are important for businesses of all sizes because it allows startups the opportunity to compete with well-established companies. The three laws created were the Sherman Antitrust Act, the Clayton Act, and the Federal Trade Commission Act. The Clayton Act is a civil statute and primarily focuses on unfair mergers, such as Coca-Cola and Pepsi merging into one. These laws are general, so courts can base judgments off of current markets and trends. As markets and trends change, a monopoly is not fair nor ideal for consumerism. Chapter 12, Unfair Trade Practices and the Federal Trade Commission. The Federal Trade Commission enforces consumer protection laws. False advertisements and taking advantage of consumers are considered unfair trade practices. Businesses should want to have honorable and upright companies that have integrity in what they sell. The Federal Trade Commission is an important part of consumerism. These laws are important for consumers to know that they can contact the Federal Trade Commission when being presented with unlawful business tactics. This agency goes after false advertisements, misleading price information, and taking advantage of consumers. Also, there are scammers and companies alike that are out to con people out of their money. For example, those who target non-English speakers through telephone scamming to try and gain personal information or funds. For these reasons alone, it shows the value of the Federal Trade Commission.
Chapter 13. International law relates to the policies and procedures that govern nations or govern relationships among nations. The purpose of international laws are to permit countries as much authority as possible over their own international business affairs, while maximizing economic benefits of trade and working relationships with other nations. International customs, treaties, and organizations are the primary sources of international law. One of the most important considerations for international business is understanding that companies operating in foreign nations are subject to the laws of those nations. When international laws are violated, disputes are often resolved through the legal systems within individual nations. The Foreign Commerce Clause enables Congress to regulate commerce with foreign nations and permits U.S. businesses to actively negotiate and implement taxes or other regulations as they relate to international commerce. After the social and economic unrest of the 1929 stock market crash, Congress passed the Securities Exchange Act of 1934. The liabilities for companies not complying include monetary fines, civil penalties, and criminal proceedings. Publicly owned companies that meet certain size requirements are called reporting companies and must file periodic disclosures. The purpose for these disclosures is to help investors make educated decisions regarding how to invest their money. These disclosures include information about a company's line of business, corporate members, and financial statements.